Hello, everyone, and welcome to Uncivil Law. For today's case, we have a follow-up on the Myrtle Beach shooting. This is Benton versus Blue. If this sounds familiar to you, it's because we live streamed the audio in the Court of Appeals. The Court of Appeals has since rendered a decision. If you're wondering, yes, that is fairly quick for a Court of Appeals to turn this around. But now we have a decision from the Court of Appeals for the Fourth Circuit regarding this police shooting and whether or not it's okay for the police to bust down your door and shoot you 29 times for a little bit of pot without giving notice or warning, even though they didn't have a no-knock warrant. So we're going to read the opinion from the Court of Appeals for the Fourth Circuit and determine whether or not this is okay. So let's get started with that. Although I probably don't need to remind you of the facts, let's see what this Court of Appeals, how they summarize the facts and put it in their words. In the afternoon of April 16, 2015, a team of plainclothes law enforcement officers armed with assault-style rifles used a battering ram to enter Julian Ray Benton's dwelling to execute a warrant authorizing a search for marijuana and other illegal substances. The officers did not identify themselves as police or otherwise announce their presence before employing a battering ram. 3 officers, including Myrtle Beach, South Carolina police officer David Blue, fired a total of 29 shots at Benton, striking him 9 times. Benton suffered permanent paralysis resulting from the gunshot wounds. While Officer Blue originally maintained that Benton had been the first person on the scene to fire a weapon, a later investigation revealed that Benton never discharged his .45 caliber pistol. So it turns out the police kind of fudged the facts a little bit. Thereafter, Officer Blue revised his account of events, stating that Benton had pointed his weapon at officers. Well, I guess it's nice when you can change your testimony from one thing to another thing. What is this, Phoenix Wright? Just keep testifying till you get it right? Okay, carrying on. Benton filed suit under 42 U.S.C. 1983. Officer Blue moved for summary judgment on the grounds of qualified immunity, and the district court denied the motion. Officer Blue appeals only the denial of the qualified immunity with respect to the excessive force claim. So the police said it was totally cool for them to do this, and if it wasn't totally cool, they didn't have notice that it wasn't totally cool, and therefore it's all okay. The district court disagreed. Let's see what the Court of Appeals has to say. We agree with the district court that disputes of material fact preclude the award of summary judgment. A jury could reasonably find under these facts presented that Benton did not pose a threat to the officers, justifying a use of deadly force. Oh, a jury could actually look at this and determine that you did a no-no. Yeah, so go back to a jury and convince them. Good luck with that plan. In 2015, the Drug Enforcement Unit in South Carolina began investigations into Benton, who lived in a duplex-style residence in Myrtle Beach, South Carolina. Agent Chad Guess, what's it with Chads, am I right, led the investigation and worked with a confidential informant who purchased marijuana from Benton at his home on 2 occasions. The informant paid Benton about $100 each transaction. The respective amounts purchased were 7 grams and 8 grams of marijuana. I'm not saying that it isn't illegal, but don't we have better things to do with our time than go after someone who's selling 7 and 8 gram amounts? And even if we don't, can we not storm their door like they're the biggest drug expert ever? I'm just saying, this seems like a little much given what's alleged. Okay. Agent Guess obtained a warrant authorizing a search of Benton's residence for marijuana and other illegal drugs. The warrant permitted entry into Benton's residence using the standard knock and announce procedure, requiring the officers before forcibly entering, in the absence of a response, to knock and announce. Yes, knock and announce is the default rule. They have to knock and announce, give you a chance to open the door. It has to be a meaningful chance. That didn't happen here. Prior to executing the search, Agent Guess led about 10 DEU agents, including Officer Blue, in a pre-search briefing. About 3 p.m. on the day of the search, 11 law enforcement officers in 3 unmarked cars arrived at Benton's home. Although the car's emergency lights were activated, the sirens were not. The shades on the front window of the home were drawn, blocking any view through the windows. The agents were wearing a variety of plain clothes and bulletproof vests. Officer Blue wore a baseball cap, and another agent wore a black cloth mask obscuring the lower half of his face. Once again, putting aside the legal issues at play, How is the homeowner in this situation supposed to distinguish this from just a home invasion? They're a bunch of plainclothes people, and one of them has cloth covering their face. So how's the homeowner supposed to know whether or not this is a home invasion or whether or not it's police activity? Wow. Without knocking or announcing their arrival, Officer Blue opened the screen door while Agent Guess used a battering ram to gain entry through the front door. Officer Blue then followed two other agents as they entered their home with their assault-style rifles. No knocking and announcing. They violated the terms of the warrant. That's a bad thing. You shouldn't do that. At the time, Benton was leaving a bathroom in the back of his residence. Hearing the break-in, but no verbal commands or other indications the intruders were members of law enforcement, Benton reached for his gun. This makes sense. This is something that a homeowner in the United States might do. People are busting into your home. They haven't yelled police. Might you bring your gun to deal with this situation? Yes. This is totally normal behavior. Benton stated that he held the gun by his hip. I had it down. I didn't get the chance to pull it up or anything. 3 officers, including Officer Blue, fired a total of 29 shots at Benton. Officer Blue fired 9 of the shots. The agents ultimately recovered about 220 grams of marijuana from Benton's home. Again, I'm not saying that it isn't illegal, but 220 grams of marijuana. We shot the guy 29 times and hit him 9 times and paralyzed him. I'm just saying, it seems to me a bit much for what's alleged. We could have done this, more civilly, but no, Myrtle Beach Police Department isn't allowing for that today. Officer Blue also initially asserted that the agents had knocked on Benton's door and announced their presence, and waited before forcibly entering. However, footage from video cameras on Benton's front porch showed the officers had not knocked and announced their presence and had not waited any length of time. The officers said that he fired first. The officers said they knocked and announced. He didn't fire first. They didn't knock and announce. Police are fudging the facts once again here, guys. To the contrary, the video recordings show the officers ran up front steps and immediately began using the battering ram. And that's true. We saw the video. It was immediate. The record before us also contains statements from a former DEU agent who related that DEU agents almost always forcibly enter the residence without knocking and announcing. So this is going to a pattern of conduct. This is going to their normal training and methods. That makes it a 1983 violation. Yep. Manitoban, you ask, when does perjury come into play with a cop? Well, hypothetically, it should be exactly the same as for anyone else. So, but here's the catch. And I know you know this already. Perjury is a criminal charge. Yep. Which means that in order to charge them, the police would have to arrest themselves, and or the district attorney would have to file a charge with the grand jury. So, there's that. Yeah. As a result of the shooting, Benton was placed in a medically induced coma for 6 weeks, endured numerous surgeries, and now is permanently paralyzed. In his complaint, he alleges violations under 42 U.S.C. 1983. Officer Blue filed a motion seeking summary judgment on the ground of qualified immunity. The magistrate judge found the officers had not knocked and announced their presence before entering, and there were no exigent circumstances warranting abandoning the knock and announce procedure. With respect to Benton's excessive force claims, the magistrate judge found that there was material facts in dispute regarding whether Benton had pointed a gun at the officers before Officer Blue fired the weapon. Thus, the magistrate judge concluded a jury could find that Benton did not pose an imminent threat of death to Officer Blue or others. And fair enough, this is issues for a jury. This whole thing is ultimately about whether or not there should be a jury trial at all. Benton was arguing there should not be a jury trial at all, that he was just excused as a matter of law. So yeah, whether or not Blue really did have the gun by his side, whether or not he really did pose a threat, these are issues for a jury to decide. Now, a jury might take notice of the fact that the officers have fudged the truth in factoring in whether the officers now testifying might be also fudging the truth. So I would suspect the officers are going to have a difficult time convincing a jury of that they didn't violate their rights here. But this whole thing is about whether or not there should be a jury trial. So yes, we should have a jury trial to determine whether or not they violated the law. Yep, makes sense. We first consider whether the facts as alleged show that Officer Blue's conduct violated the Fourth Amendment. According to Officer Blue, the factual question where the officers had announced their presence is relevant only to Benton's separate claim of unlawful entry, which is not the issue in appeal. We disagree with Officer Blue's argument. And we heard them express that disagreement during the oral argument that we previously streamed, where, yes, the county's attorney made exactly this argument, and the judges responded with varying degrees of incredulity that they're making the argument, with one judge saying, no, 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 as I remember them saying on the audio. So, yeah, this was the argument. We heard the judges say it in oral that this made no sense. Now we see it in writing. It makes no sense. So, there we are. We evaluate whether an officer has used excessive force based on a standard of objective reasonableness. An officer may use deadly force when an officer has probable cause to believe that a suspect poses a threat of serious physical harm, either to the officer or others. We have explained that an officer does not possess unfettered authority to shoot because of mere possession of a firearm. Right. The Second Amendment to the Constitution provides people have the right to keep and bear arms. So someone having a possession of a firearm in and of itself does not make it illegal. So that doesn't give you the authority to shoot, because that would undermine the Second Amendment. Yeah. Instead, an officer must make a reasonable assessment that he or another has been threatened with a weapon in order to justify this force. Our decision in Cooper is determinative. There we concluded that a suspect who was holding a firearm at his side on his property while investigating a noise outside his home did not present a threat to the officers. Again, both in the present case and in Cooper, this is something that you might expect in the United States of America. Because people have the right to keep and bear arms, people, when investigating a suspicious event on their own property, might use a firearm to protect themselves. This is part of the point of the Second Amendment to Second Amendment advocates. So yes, the fact that in Cooper he had it by his side while he was investigating noises on his own property makes sense. Here he had a firearm by his side because people busted down his door and the people were wearing street clothes and were wearing masks, which makes sense. So it doesn't make sense that on the one hand, a person can lawfully exercise their Second Amendment rights, and on the other hand, an officer can shoot them for it. So yeah, that makes total sense to me. Moreover, we've stated that if officers have identified themselves as member of law enforcement, they may have been reasonable, including that a man who greets law enforcement with a firearm is likely to pose a threat. Instead, in the views of the facts presented, we held that Cooper had a reasonable rationale for bearing a firearm while investigating a noise on his property, and thus the officers were not entitled to qualified immunity. So in the prior case, the officers had made the same argument, that merely because you had a gun means they're a threat. And the Court of Appeals previously said, no, that's not right. And so that gives you notice of the law. That makes it a 1983 violation because the court has previously ruled this exact issue. Right. Officer Blue shot Benton, who was holding his firearm down, without first identifying himself as a member of law enforcement or giving any commands to Benton. We reject Officer Blue's attempt to distinguish Cooper by arguing his own version of the evidence, namely that Benton drew his pistol in the direction of coming up from the waistband of the officers. And again, we heard them reject that during the oral argument. We saw the attorney trying to color the facts, and the Court of Appeals was having no part of it. The Court of Appeals repeatedly said, you don't get to make up your own facts. The court below said, these are the facts. These are the facts. These are all there is. And he kept trying to change it. So yes, they rejected Officer Blue's attempt to provide his own version of the evidence. They did that orally. They smacked him down hard. Now they do it in writing. You can't do that. Yep, you can't do that. The court below has made a factual finding. Those are the facts. Go away. Benton was asked in his deposition numerous times to describe his conduct that preceded the shooting. According to Benton, he heard the front door kicked in while he was in the hallway after leaving the bathroom in the rear of the residence. After the initial noise, Benton heard no other sounds, and when Benton was maybe a step away from the living room where the front door is located, Benton saw stuff coming at him in the form of strange shadows rather than people, and instinctively reached for his gun in his waistband. Again, this is the kind of thing that you might expect to happen. Yeah. Benton stated that once he removed the gun from the waistband, he held the gun by his hip. I had it down. I didn't get the chance to pull it up or anything. The magistrate judge and the district court construed the facts in Benton's favor as required at this stage of the proceeding and concluded that Benton had reached for his gun and held it by his side when the officers fired 29 shots without a warning or issuing other commands. Again, it's a bit much. If Officer Blue or another officer had identified themselves as a member of law enforcement, Officer Blue may have reasonably believed that Benton's presence while holding a firearm posed a deadly threat to the officers. Fengo today says, can any of this appeal be used at trial? No, not really, but the prior testimony and statements from the officers certainly can. So where they made misrepresentations of the facts, that can certainly be brought in to impeach them. The court here is assuming that everything that Benton is saying is true. They're required to. Under his view of the facts, this is what happened. So that's, they have to go back and prove this at trial. Personally, I don't think it's going to be that hard. These are legal determinations, not factual determinations. Juries get to determine the facts. So they will have to decide whether or not Benton did, in fact, have his gun by his side or not. Personally, I think they're probably going to say that they are, because they're probably not going to believe the officers, because the person, when they cross-examine the officers, is going to say, isn't it true that you basically lied and corrupted the record, and by the way, here's the video proving that you lied and corrupted the record, and that basically you're untrustworthy scoundrels? So I expect Benton's going to have a fairly easy go of it at trial, all things considered. Having determined that Officer Blue's actions in this circumstance violate the Fourth Amendment as a use of excessive force, we turn to consider the second step of the qualified immunity analysis, whether Officer Blue's conduct violated a constitutional right that was clearly established at the time the conduct occurred. Our conclusion is not altered by Officer Blue's attempt to distinguish Cooper in two respects. The prior case that basically had the same facts, the guy outside the home with the firearm by his side. Arguing that it was not feasible to give warning given the split-second situation, and arguing that Benton was a fugitive, an active drug dealer. Just no. None of those things seem relevant here. But here, like the officers in Cooper, Officer Blue and his fellow officers could have announced the police presence at any time before shooting. Right, they could have, and in fact, were supposed to. They had a knock and announce warrant. Announce means announce. So, they didn't do that. They could have, should have, and didn't. Right. Second, no information in Benton's criminal history suggests that he was inherently violent to a degree the officers would have been justified in storming into his home unannounced and firing their weapons at him when he did not present a current threat. For these reasons, we affirm the district court's order denying Officer Blue's motion for the summary judgment and remand the case for further proceedings. So that is the follow-up in the case of Benton versus Blue. In this case, we learned that the Fourth Circuit Court of Appeals, when they were being very incredulous to the government's attorney who was making the arguments, is just as incredulous in the written word. The Court of Appeals does not believe a thing the officer said. And they said that, yes, there is not qualified immunity because there was notice of this, because this parallels a situation that had already happened. So go back to trial, figure out whether or not Benton was in fact having the firearm at his side. Probably the jury is going to say they are. And if so, you're going to have to pay him some monies. But perhaps even better, perhaps you could stop doing this in the future. We have learned from our prior coverage of this issue that this is not untypical practice for this unit in South Carolina. They seem to do this all the time. Here's a thought, guys. You could just stop doing this. You could wear proper police uniforms. You could knock and announce. You could say police. You could follow the rules of law. And also, you could not exert this kind of deadly force for nickel and dime counts of marijuana. I mean, there's got to be better things to do with our time. But that is the end of this case for now, and we will cover the inevitable court of decision from the district court whenever they get around to their trial. So that is the end of the case for now.